Good morning, everyone. Welcome. Welcome to our second Gardiner Roberts Toolbox Seminar of 2016. For those of you who don't know me, I'm Lorne, Saltman, the head of the tax group, and very pleased to have you join us in person or on the webinar. We have people who are in their offices and joining us as well. What we decided to do today is to help you identify problems that you or your clients may find and ways in which you can avoid some of these problems either by self-help or by going to court, and when you do have problems, how we can help you work your way through and solve these problems. Maybe avoiding court is a way of solving a problem as well. Our speakers today, our first speaker is Tim Duncan. Tim is a member of our litigation group and in particular focuses with us on estate litigation. And Tim's going to talk about a case today that illustrates some of these issues about problems solving and maybe when not to sue. As well, Lindsay Histrop, my co-chair of these sessions, head of our estates group, will be speaking about estate planning and some of the issues that you want to identify up front to avoid and plan around. And I'll be talking about a remedy that has become quite popular and controversial lately, rectification, going to court and trying to change what happened without offending the sensibilities of the Canada Revenue Agency. So please feel free to ask questions. We'll be here afterwards as well. And you've been given at your seat not only the programs but also an evaluation sheet. Please do fill it out. We appreciate your comments, and in particular if you've got suggestions as to topics that you'd like us to talk about next time, that would be great. So Tim is our first speaker. Go ahead.
Thank you, Lorne. Good morning, everyone. Welcome to another exciting edition of Gardiner Roberts Toolbox Seminar. It's just after 8 a.m. in the morning, and I'd like you all to give yourselves a pat on the back for making it out bright and early to be with us today, especially after another exciting but devastating loss to the Cleveland Cavaliers last night. Unfortunately, I don't have any advice to give them on how to win in Cleveland. Just a couple words about myself. Lauren's already introduced me. I am a litigator here at Gardiner Roberts, and I am specializing in estate litigation and commercial litigation matters. I'm not going to be speaking to you for very long, so I've decided to focus in on one particular case. It's a very interesting case, and also a fairly recently released decision of the Ontario Court of Appeal. I've read a few cases in the years that I've been doing this, and I have to say, from the state litigation point of view, this one sort of seems to have it all. And you'll understand what I mean by that when we get to the end here. So the case is Neuberger and York. And there's a couple of ways that we could come at this case, but I think I'll start with a very brief skeletal discussion of the judicial history of this case. The last thing that we're dealing with is an appeal from the Superior Court of Justice. It was a decision of Madam Justice Greer. And for those of you who aren't familiar with Justice Greer, she's an esteemed member of the estates bar and a highly qualified judge. So anytime she's going to get appealed, it's going to probably get some notice. There was an application to challenge the validity of the will. And the twist here is that the application is in fact brought by the estate trustee under the will. So that sort of immediately says, okay, well that's a little bit strange. But this is all going to make sense as we start to go along. In any event, the co-trustee under that will moved to have this application dismissed. And this will start to fill you in. Co-trustees, sisters. And we'll discuss her grounds for moving to dismiss a little bit later. But on first instance, Justice Greer, she agrees with Myra York and dismisses the application of Edie Neuberger. On appeal, however, Justice Scalise overturns Justice Greer. Okay, so a little bit about the family here. The testator is a man by the name of Neuberger. He had a fairly remarkable story. He was a Holocaust survivor, born in Poland in the 1930s and immigrated to Canada sometime in the 1940s. And when he got here, he did very well, and amassed a real estate empire worth well over $100 million. His family includes his wife, Sarah. She predeceased him, so she wasn't in the picture for this particular battle. And his daughters are Edie and Myra. He died in September of 2012, and he was 86 years old when he died. Okay, so that's the family. Let's talk for a second about the wills. There were, in fact, two sets of wills: primary, second, and secondary wills in 2004, and then also primary and secondary wills in 2010. Why primary and secondary wills? That's probably a topic best left for another Gardiner Roberts Toolbox Seminar. But generally speaking, that goes to organizing your estate. It's usually done for tax reasons, often when a business is going to be heavily affected by the death. But in any event, two sets, 2004, 2010. Now, there's plenty of similarities between these two sets of wills. Under both, Myra and Edie were named as joint executors and trustees. Under both, the definitions of the primary and secondary estates were the same. The primary will in both is designed to deal with Mr. Neuberger's non-corporate assets, which required a grant of probate, such as bank accounts and his RIF. The primary estate was defined as all of Mr. Neuberger's property except his secondary estate. Under both sets of wills, the residue of the primary estate was to be divided into two equal shares, with one share for the benefit of Edie and her children, and the other share for the benefit of Myra and her children. And under both, the secondary estate consisted of the bulk of Mr. Neuberger's assets and includes his interests in Company A and Company B. The secondary will gave voting control of Company A and Company B to Edie and Myra, respectively. So that's what these two sets in 2004 and 2010, that's what they have in common. What's the difference? The change, allegedly, is the 2010 wills, they no longer involve an equalization mechanism for the secondary estate. According to Edie, this is the result of an estate freeze that happens contemporaneously with the drafting of these 2010 wills. The freeze, under the freeze, Keim retains control of the companies on an ongoing basis through retention of preference shares. The common shares of Company A and Company B are now held in separate trusts. Edie and Myra and their children are the respective beneficiaries of those trusts. The effect is any inequity in capital stock as between the two companies now does not get rebalanced through the primary estate. This is what Edie is alleging in any event. And apparently a rebalancing would have occurred under the 2004 set of wills. So under these new 2010 wills, then Edie appears to get the short end of the stick to the tune of around $13 million. Out of a $100 million estate, I don't know if that's such a big deal, but apparently it is. I guess $13 million is a lot of money. Hence, you have a challenge to the validity of the 2010 wills. Okay, some background information here that also plays a role into understanding how these decisions get made at the Superior Court and the Court of Appeal. Edie took some steps as the estate trustee under those 2010 wills. What she did was she did things like write to Maple Leaf Sports Entertainment and get a transfer of season tickets. She objected apparently to certain engravings being included on Keim's gravestone. Something to do with his Polish nickname. Edie didn't like it. Myra had put it on there. Edie made requests as a state trustee under those 2010 wills for her father's medical records, and apparently redeemed preference shares of Company A. Now, notably, there are certain steps that are not taken by Edie as a state trustee. Neither Edie nor Myra had applied for a certificate of appointment as a state trustee. Myra and Edie, they never met or jointly retained counsel to advise them in their roles as state trustees. No distributions were in fact made from the estate, and Kimes shares in Company A and Company B were not disturbed. What did happen, however, were legal proceedings were brought by Edie as a state trustee under the 2010 will. And Edie took the first shot here. She applies to pass over or remove Myra as a state trustee under that 2010 will. And she does that in April of 2013. Shots go back and forth from there. In December of 2013, Edie commences her challenge to the validity of the 2010 will and argues that Kime lacks testamentary capacity in 2010 to make those wills. In January of 2014, Edie's son, Adam, he becomes an active member in this new application by Edie. He brings a motion requesting that the 2010 wills be proved in solemn form, more or less backing up what it is that Edie's doing with her challenge to the validity of the will. And Myra then moves in February of 2014 to dismiss the application. And that brings us up to speed of where the litigation is at. So let's take a look at what Myra's arguments were when she moves to try to dismiss this application. She basically brings these arguments based on some equitable doctrines as opposed to legal doctrines of estoppel. And there's two different versions of estoppel that she relies upon: estoppel by representation and estoppel by convention. Okay, so what does that mean? The doctrine of estoppel by representation holds that if a party makes representation or conducts herself in such a way to induce another party to act or not act, and that other party suffers a detriment as a result, then equity will intervene and preclude that person from taking that new position, which is also contrary to the position taken earlier. That's a very rough outline of what it is. The doctrine of estoppel by convention is just a little bit different, where there is an assumption between the parties as to a state of facts regarding mutual assets based on express statements or based on conduct, and no party challenges the assumption within a reasonable time frame, then equity will again intervene and preclude either party from taking a new and contrary position. So Myra looks at what Edie's now doing with this new will challenge and points to these doctrines and says, well, not so fast. When we look at your conduct in a number of areas, taking steps as trustee under those 2010 wills, this should preclude you from now showing up and challenging the validity of those wills. And Justice Greer agreed with this. Justice Greer applied these doctrines of estoppel and dismissed the application. And in so doing, Justice Greer pointed to the fact that it really appeared like insufficient haste had been taken by Edie in bringing this application to challenge the validity of these wills. And the evidence did establish that Edie had suspected Kime of lacking capacity as early as 2010 or 2011. The other notable thing that Justice Greer finds in the first decision is she finds Adam, the son of Edie, who's shown up and has asked that the 2010 wills be proved in solemn form. She finds that he's a straw man for Edie. Justice Greer pointed out that Adam had no independent knowledge of Kime's state of mind, no relationship with Kime, and he was also, like Edie was, rather late in time to be showing up and now saying these things. So the application in first instance gets dismissed. But when Edie appeals, the Court of Appeal says to Justice Greer, also not so fast. So these estoppel doctrines that I spoke about that were the grounds for the motion and formed the basis of Justice Greer's decision, these haven't been applied in probate matters before. This is rather without precedent. And what Justice Scalise at the Court of Appeal says is that there's significant policy considerations in play that are particular to probate that make these estoppel doctrines ill-suited. The court's role in probate is not simply to mediate disputes between two parties that show up. Estoppel principles are concerned solely with the relationship between the parties at hand. But Justice Scalise says that the court has a duty to the public at large to ensure the estate is handled properly. By probating a will, the court declares to the world at large that the estate trustee holds good title and has lawful authority to administer the estate. And there's also a duty, of course, to the testator. The testator is not there and not present to voice his intentions at that time. And Justice Scalise also points to another policy factor at play here. She says that estate trustees need to be given a reasonable amount of time to contemplate the circumstances of the will that they're appointed under. Justice Scalise says that Justice Greer's reasoning about insufficient haste would place estate trustees with doubt as to will validity in a precarious position. Either they'd be forced to bring a premature will challenge, or they take no steps in estate administration for fear of appearing to confirm that will. So it creates a chill. And Justice Scalise says, policy considerations, that's not good. We don't want to put trustees in this entirely precarious position. Dealing with Justice Greer's finding that Adam was a straw man for his mother, the Court of Appeal was fairly critical of Justice Greer on this point. And this is important. The only evidence as to how and why Adam came to be involved on the motion, that had come from Adam and Edie. Okay? No one on Myra's side had presented contrary evidence or disturbed Adam or Edie's story on cross-examination. They only raised the allegations and said, well, he's a straw man. Obviously, Justice Greer agreed with those allegations, but Justice Scalise's counterpoint to Justice Greer is an important one basically on civil procedure. Scalise says, if the motion judge rejected Adam's evidence, which would necessarily entail credibility determinations, it was incumbent upon her to give some explanation for so doing. In other words, you can't move so fast, not so fast. In making those judgments, there's a process here for weighing evidence and making those sorts of decisions. And Justice Scalise also says that just a finding that he's a straw man doesn't bar him from bringing his motion in any event. I'll just say one brief word about another thing that the court touched upon here. This wasn't the basis for the decision, but it's an important point on estate matters and dealing with probate litigation that Justice Scalise raises. On this point, Justice Greer and Justice Scalise entirely agreed. On the original motion, Adam had argued that his rights could not be dismissed under Rule 7501 because he had an automatic right to proof in solemn form as opposed to common form. Justice Scalise addressed this point, and what the rule actually says is an estate trustee or any person appearing to have a financial interest in an estate may make an application under Rule 7506 to have a testamentary instrument that is being put forward as the last will of the deceased proved in such manner as the court directs, so not an automatic right to proof in solemn form. And this makes good sense. If this right was automatic, litigation could potentially spiral out of control. People could bring applications a little bit too easily. And that's a very important policy statement that the Court of Appeal makes. So when we look at what happened here, you have a very experienced Superior Court judge and then getting overruled at the Court of Appeal, and you kind of, okay, well, how did this happen? In defense of Justice Greer, this seems to me to be a clear effort by Justice Greer to be practical and equitable. I think, she takes a look at what Adam was, called a spade a spade. Justice Greer has many years. She probably has a nose for these sorts of things. It also seems unlikely that Kai meant to favor one side over the other when you look at what he really did. And also, will challenges are supposed to be based on actual belief of lack of testamentary capacity, not, gathering the facts afterwards, realizing, oh shucks, I'm out $13 million. Oh wait a minute, you lack testamentary capacity. That's not supposed to be the idea. And so this certainly looks like Edie's application was a matter of convenience for her, and perhaps it was. And Justice Greer maybe had nosed that out. However, bad facts made for bad law, and practicality has its limits. To dismiss an application in this way prior to trial is a big deal, and the decision turned on application of equitable principles of estoppel, but there just isn't any precedent for that. So inviting these doctrines into probate litigation is potentially a can of worms. The lesson at the end of these war stories, of course, as always, before you get too far down any of these roads, is make sure that you talk to very, very capable estate lawyers, Gardiner Roberts, when you plan your wills. Make sure that these things are laid out ahead of time. Thank you all for your time. I'm out of time. We like to run a tight ship. If anybody would like to speak to me afterwards, I'll be around. Thank you.
Thank you, Tim. I'm going to be speaking about rectification, and I'm heading up this subject as a useful but not universal tool to remedy mistakes. I'm going to explain what is rectification. I'm going to talk about some leading cases in the tax courts. I'm going to talk about why the Canada Revenue Agency gets very troubled by some of these applications for rectification, and looking at other areas of the law, whether it's trust law or contract law, for some understanding of the underlying equitable principles, a little different from what Tim is talking about in terms of pure estate matters. This is broader. And then finally, some unusual applications, including foreign rectification orders. So let's start with an understanding of the basics here. What is rectification? Well, there are, as Tim mentioned, common law principles and equitable principles that in equity, the court has inherent jurisdiction to remedy what is viewed as being harsh, unfair, unconscionable, or unjust. And a superior court of the province has the ability to give relief. So let's try to understand the scope of that relief. Traditionally, it's been looked at in terms of having parties to an agreement saying, okay, here's what we want to do. They try to put it into a written form, and somehow it gets mistakenly put into the written form. Doesn't exactly reflect, because of mistakes, what they had agreed to. And so the remedy is for the court to look at, well, what was the original intention of the parties? And maybe we have to substitute certain words or change the contract in writing to reflect what was there originally. Rectification is one type of remedy which we're going to focus on because of its use in the tax world. But just very briefly, there's another equitable remedy called rescission, where parties think they've got an agreement and they then go to implement it, but it turns out that it's different than what they understood it to be, and they don't want the agreement at all. And so the court is prepared to rescind the agreement or turn it around. And just to give you a very brief example, a case called Repalin Trust of 2015, a very recent case. There was a settlement of the trust, and it was done with legal and accounting advice to avoid attribution under subsection 75(2), where if you transfer or, according to the Canada Revenue Agency, sell assets to a trust, you have to be very careful, because the resulting income or capital gains could be attributed back to the transferor. So parties went about complying with the Canada Revenue Agency rules, but then there was a tax case called Somerer, which was decided, and you may recall from previous seminars we talked about it very briefly. An arrangement was set up offshore with a foundation as opposed to a trust. Property was transferred in, subsequently sold, and the Canada Revenue Agency said that the gain that was realized by the foundation was really attributable back to the taxpayer transferor, and the court said no, it was sold at fair market value, and the settlement has to be done by way of a gift. Well, the Palin folks were caught short because this new case came in, and they had to look at their own situation. They went to court, and they said, we thought we were doing the right thing according to the Canada Revenue Agency guidelines, but the court said it's a whole different ballgame. We don't want to have the transfer into the trust take place at all. And the court agreed, and they rescinded it so that there was no attribution. That's a very unusual situation. Much more common is making a document, making a change in a document to reflect the intention of the parties. So the idea is undo basically through this tool of rectification. Let's look at what are the elements that have to be proven in order to establish that you're entitled to rectification. First of all, the parties have to have a common intention that has to be proven with evidence before making the written instrument. It could be a contract, it could be a deed of trust, whatever. This common intention has to continue unchanged from when it was orally agreed to the time that the written document was executed. The written instrument, there has to be a mistake that can be clearly pointed to show that the written document didn't reflect the prior common intention of the parties. And this is a little bit controversial. We'll get into this further. The parties have to show the form that the written instrument can be changed to in order to express that common intention. As we'll see in a little bit, the courts have grappled with whether that can be a general intention, not to pay tax, say, or a precise intention. We must have this changed to that document. I'm going to talk for some time about the Juilliard case, which is the leading case in this area. It was decided in 1999 in Ontario at the Superior Court level, and then confirmed the Ontario Court of Appeal, and an appeal to the Supreme Court was turned down. So in Ontario, clearly this is the leading case on rectification. Some other provincial courts have questioned whether Juilliard was properly decided in their context, but overall I think it's fair to say this is the starting point for understanding what rectification is and the scope of it. Here we've got a family that was doing an estate freeze, and just in essence what happened was they thought they were doing a transfer that would be tax-free, and instead of getting shares only, they got promissory notes, a mistake. How can we deal with it? They had a holding company, 867, which held shares of the operating business, and the family wanted to divide it up among the members through the estate freeze process, and that the Juilliard family had a common and continuing intention. The court found that this transaction take place without triggering any tax liability. They transferred their shares in 867 to a new holding company, but they, based on the accounting advice as to what the adjusted cost base would be of the shares being of the operating company shares being transferred in, they thought they had more ACB than they actually had. So they took back excess boot, too much in the way of promissory note in excess of the adjusted cost base, and under the Section 85 rollover rules, that triggers a gain. And under, furthermore, it could be a deemed dividend under subsection 84(1), so we have to be very careful here. So they should have received shares to cover that differential in the boot to defer the tax liability. The court found that the Juilliards had a common and continuing intention to avoid a tax liability in a broad sense. The court didn't say, well, it's very clear that they had agreed there would be shares and no promissory notes. It wasn't necessary for the court to find that rectification was an appropriate remedy. It was enough that they had a common intention not to trigger any tax liability. And the court commented, I think this is worth noting when we think about the intervention of the Canada Revenue Agency in these cases. Denial of the application by the Juilliards to repair the mistake would place on them a heavy burden which they were entitled to avoid and which they sought to avoid from inception. In addition, it would give to the tax department a premature gain solely because of an error in the understanding or communication between the advisors and the client. So there's no windfall here for the Canada Revenue Agency simply because there was a miscommunication. And as I mentioned, the decision was upheld by the higher courts, and they found that there was no necessity to prove a specific intent that the holding company issue shares instead of debt. Now, while that is the leading case, the Canada Revenue Agency does not sit back lightly and blithely accept all rectification applications. They are becoming, I would say, even more attuned to taxpayers wanting to make changes, which sometimes the CRA feels are inappropriate. And they will argue you have to have a specific intent to use a particular instrument or structure, or because a general intent is not going to be good enough. Some courts outside of Ontario have accepted that. Plus, the CRA is saying rectification has really gone too far. It's now permitting retroactive tax planning. And we in this firm have gone through some rectifications in the last couple of years where we've seen the Department of Justice on behalf of the CRA and the CRA itself, even if the CRA initially is willing to consider rectification for a mistake, they really zero in on trying to understand the elements that make it up and to make sure that there isn't retroactive tax planning, that really there is an appropriate remedy to repair a mistake as opposed to after the fact the parties realize tax consequences that are severe. They want to avoid those tax consequences by restructuring ex post facto. That will not go. And we'll give some examples in a moment. So as I say, in other jurisdictions in Canada, there have been stricter approaches taken. And we're soon going to be looking at the Supreme Court of Canada entertaining two cases that have come up from one in Quebec, the Jean Couteau case, which denied rectification, and another case called Fairmont Hotels from Ontario, which permitted it, and we'll talk about both of them. But let's focus on this negative one first, Jean Couteau. And it's going to be interesting because in some ways similar underlying problems and facts are slightly different, but the courts take very different positions. This is a Quebec-based company, a very successful one, that expanded its pharmacy business into the United States. And they set up a subsidiary or series of subsidiaries in the U.S., and they were funding with loans and debt into the U.S. Operations, and they became concerned about the differential in exchange rates between the Canada and the U.S. dollar. And they were looking at how the Canadian dollar had depreciated against the U.S. dollar. They thought, we better do something to protect against a negative view of our publicly disclosed financial statements. And so they looked at two plans proposed by their advisors to hedge against that foreign exchange risk. The first plan involved lending capital from the Canadian company down to the U.S., buying some additional common shares in the U.S. subsidiary, and then having that U.S. subsidiary loan the proceeds back to the Canadian company. And because the movement back and forth would be U.S. dollars, they felt that was a successful hedge against the proposed or the exposure to the currency risk. But you'll notice what I said was there was a loan back from the U.S. sub upstream. It bore interest. The Canadian parent had a controlled foreign affiliate that was earning interest income. They fell into a trap. It produced FAPI, foreign accrual property income, even though those rules are really intended to prevent Canadian companies and controlling shareholders generally from shifting income from high tax jurisdictions to tax havens. It can happen with a U.S. subsidiary, even a high tax jurisdiction like the U.S. And so when the Canada Revenue Agency came to reassess the parent for the FAPI, they said, wait a minute, this is what we intended. We intended to have simply an exchange rate hedge to avoid that kind of problem. We didn't intend to fall into this trap. We really wanted to do a second transaction, which had been proposed but rejected, which didn't have that loan coming up from the U.S. to Canada. And that's what we really intended to use. But the Quebec court said, wait a minute, as Tim said earlier, not so fast. You got what you bargained for, an exchange rate hedge. You maybe made a wrong decision, and the consequence was negative for you to produce FAPI, but you never intended to do the second type of transaction. You're stuck with the first transaction. And they declined to give relief against the unintended tax consequences. They would not let, in the court's view, the parties rewrite tax history simply because of the unintended tax consequences. What the parties intended, to insulate the parent from the foreign exchange risk, was achieved, and the documentation was consistent with that intent. It wasn't as though there was an agreement that wasn't reflected in what instruments were drawn up. To substitute the second plan, the alternative would be tantamount to retroactive tax plan. And they are, and the tax department argued that a specific intent to use Plan 2 was necessary. Wasn't found. General intent, as in Juilliard, isn't good enough. As I say, the judge agreed. In the first, well, I didn't say this, but the judge agreed in the first instance with the parent company, but the Court of Appeal disagreed and found in favor of the CRA. And they said the tax liability is based on what happened and not on what a party, in retrospect, would have rather done, Plan 2 instead of Plan 1. Rectification is granted, the Court of Appeal in Quebec said, to restore a transaction to its original purpose and not to avoid an unintended effect. Now, I mentioned this other case, Fairmont Hotels, coming from Ontario. Here, again, there was a Canadian company with U.S. subsidiaries. What they were concerned with, again, was foreign exchange risks. And they went through plans that would have resulted in avoidance, but when the company was taken over, and I think it was put into a REIT, they assumed that the transactions had been properly done to avoid that exchange risk, and they redeemed some shares, and unexpectedly, it had not been done as they had hoped for, and gains were triggered that they didn't expect to have triggered. And the court in Ontario said, well, according to Juilliard, you had a general intent. It wasn't it wasn't reflected in the documents, and so we're going to give you rectification. Canada Revenue Agency said that's retroactive tax planning, and we're going to take this to the Supreme Court of Canada. So now we've got these two situations, both based on transactions to avoid foreign exchange risk. One in favor of the taxpayer, the other in favor of the Canada Revenue Agency. So now this national question will be decided by the Supreme Court of Canada, and it'll be interesting to see how they come down. Let's turn now to a little bit of an unusual situation. We talked about superior courts of the province in Canada providing a rectification. What happens if you get a foreign court that rectifies documents? Well, here's an actual case from this year, 2016, the Canadian Forest Navigation case. This is a Canadian parent that had subsidiaries in Cyprus and in Barbados, and these were generating active business income and some investment income, and they were looking at repatriating some of the funds from these subsidiaries back to Canada. And they initially had the payments described in the corporate records of each of these subsidiaries as dividends. But when the Canada Revenue Agency did their audit and they looked at these receipts in the Canadian parents' now, they said, these are going to be taxable. You don't have enough exempt surplus to get a full deduction of computing taxable income. And so well, actually, the Barbados dividend was assessed. The Cyprus dividend was about to be assessed. So facing these these challenges about foreign receipts from foreign sources, the company went to the courts of Cyprus and Barbados and asked for rectification. We didn't intend, they said, to have any tax consequence based on the Juilliard principle. Please change the dividend to a loan distribution. And each of the courts in Barbados and Cyprus did that. Now they came to Canada, and they applied to the Tax Court of Canada for an order to say, in Canada, you must accept the foreign rectification orders and enforce those court judgments here in Canada and stop the Canada Revenue Agency from assessing a taxable dividend. You should recognize these as loans which are not taxable. But the tax court did not agree. They refused to make these orders, and they said, and it happened to be Quebec where the parent was located, but the same principles would apply right across Canada. When you look at enforcement of a judgment, you have to look at what are the Canadian attributes of how we look at foreign orders, and be very practical. If the transaction really is a debt, would it be correct to say that a Quebec civil court might seek enforcement if the foreign affiliate actually wanted to enforce the debt against the Canadian parent? Questionable whether that would be the case. And you have to look at key factors to decide whether the foreign judgment is enforceable. And here are the principles that have been laid out in the jurisprudence. Will the foreign judgment disturb the structure and integrity of the Canadian legal system? Certainly Barbados and Cyprus follow the common law tradition, which we do as well, but they're not exactly the same as the Canadian legal system. So you have to put it into the Canadian context. Does the foreign judgment conflict with domestic law? Certainly, if domestic law would say that you can't reverse the dividend and call it a loan after the fact, because that's retroactive tax planning, you have to be very careful and not enforce that foreign judgment prematurely. And will enforcing the foreign judgment result in the judges here assisting a taxpayer in something that would not have been available in a strictly domestic situation? Finally, the court said this is really an application to have the foreign judgment approved before there's even a trial. That's too soon. That's not so fast. Let's have a full hearing in the tax court, and if the parent is able to introduce the foreign judgment as evidence, then the presiding judge in the tax court can weigh the evidence and decide if the factors have been met to enforce it. Now, just let's turn now to some non-tax cases for rectification to look at the context, and in particular, what the Supreme Court is going to be looking at when it decides on these two cases that are coming up, Jean Coutu and Fairmont Hotels. There are a couple of Supreme Court of Canada cases from the early 2000s, a case called Performance Industries in 2002, and another one called Shafran and KRG Insurance Brokers in 2009, that are non-tax cases, but they are interesting in illuminating the Supreme Court's approach. In the first case, there was a sale of land, and the parties had orally agreed that there would be boundaries on the land based on yards. But the agreement said feet, and they didn't realize that until after the fact. And it had to be litigated all the way up to the Supreme Court of Canada, where finally the Supreme Court said, yeah, there was a mistake. Everybody really understood that it should have been yards, and they replaced the term feet with yards to rectify the contractual mistake. And in Shafran, there was an employee who had to sign a restrictive covenant when he left his employer, and there was a dispute about the geographic scope of the territory covered by the restrictive covenant. And when this case came up to the Supreme Court, they said there was really no clear intention that was agreed to between the parties. It was just an ambiguous scope to the geographic limit, and they didn't feel this was a mistake that ought to be rectified. So now when we think about the tax context, we see that the Supreme Court has taken a fairly narrow view in the non-tax area for rectification. Will they accept the Juilliard principles, or will they go for the more restrictive Jean Coutu principles? The key is, what's the original bargain? And we being the Supreme Court of Canada, will not belatedly repair merely an error of judgment. Here's a little bit of a discussion about trust and rectification. It is possible in this context to fix up a deed of trust if it has been mistakenly drafted. So here's a case called the Brogan Family Trust in Ontario, which from the CRA's perspective is very concerning to them. And as I mentioned, we've had rectification cases here in our office, and the Department of Justice raises this case with us all the time. Here's what happened. There was an estate freeze done of an operating company, and a family trust was set up to acquire common shares in the frozen company to get the future growth. And there were family members who were listed as discretionary beneficiaries, but now they were about to sell the shares, and they realized that some important family members have been left out. So they went to the court to have the trust rectified, and they did it without notifying the CRA. You have to notify the CRA when you're asking for rectification that has tax consequences. That in itself is a controversial issue. The court here found that, and even though the sale had taken place by this time, that it was appropriate to change the deed of trust to add the beneficiaries in to allow the trustees to split the capital gains and claim the exemption among more family members than originally done. That was okay. That was because that was a common intention by the parties, and a mistake was made, and they can rectify it. And it wasn't necessary to notify the CRA. Why? Because this had taken place during the taxation year. And it's not until the tax year of the trust would end that there would be a potential interest that the CRA would have in the matter. And so not until there's an actual consequence in the rule, or consequence in the tax terms, according to the Ontario Court, the Superior Court, would it be necessary to inform the CRA. CRA doesn't agree with that at all, and they will always say if there is any rectification that takes place during any period of time, we don't have to wait until the end of the year. We ought to be notified. As a matter of prudence and caution, we always do that because we don't want to get sideswiped getting into court and having the CRA object. We want to prepare ahead of time and make sure that they're on side with us when we go for our application. So that completes my presentation on rectification. As Tim mentioned, we'll hold the questions for later, and I'm going to turn it over to Lindsay now.
I think I'm live. Good.
Yes.
Technology is my biggest challenge this morning, just so you know. And it's very interesting listening to this discussion about rectification because a colleague of mine recently said, you know, judges are just tired lawyers. And I think when I read the rectification cases that I see a lot of judges trying very hard to help the sorry lawyer who made a mistake, which is often why there's a rectification application. And certainly the one to amend a trust deed sounds very much like it was not properly done. But I also remember my very first litigation matter as a student when I was a junior, not a junior, but I was a student on a case. And it was a very high-profile Toronto couple who had a divorce. And they had done a very long negotiation. They had settled all their affairs, and they had divided their property. And it was always assumed that the city house was in the wife's name and the cottage was in the husband's name. Lo and behold, about 5 years down the road, I guess the husband wanted to do something with respect to the cottage property. They searched title. Oh my goodness, it was in the wife's name. So, you know, even the best make errors, and that taught me always search the title. Don't believe what your client says. So in that case, there was a court application to rectify the agreement between the divorcing parties. And again, the judge was very accommodating and rectified the agreement to confirm that the cottage should be conveyed to the husband by the wife. She wasn't very happy, but it was a good result. So I'm looking at what can we do to prevent problems particularly postmortem, but also into vivos. And when I started to go through sort of all the things that I wanted to present today, I realized that I have material for a book because there's just so much that can be done depending on the circumstances. So what I've done in the overhead is really just a very high-level view and almost like a checklist of items or things to consider and try and remember. And the thing is that there's never any one-size-fits-all to these matters. I find every client who comes in is unique. Their family circumstances are unique, and their assets are unique. So it's always a customized plan. What did I do? I hit the wrong button. I said technology is not my strong point. Okay, so just do this. Thank you. Okay, forget that one. Okay, so obstacles to wealth preservation. I've done a list here. We have taxes. We have obviously creditors. We have beneficiary. We have litigation, which sometimes cannot be prevented. We have the choice of the wrong executors or attorneys under power of attorney, and that may just sound like simple common sense, but you'd be surprised. Beneficiary error, which I'll talk about a little bit, and then what should add in there as well is testator error, because sometimes after the planning is all perfectly done, the testator makes a blunder. And common will myths, and I'm always amused at how people still think that this is the way the world works. I don't need a will. My spouse gets it all anyway. My spouse owns half of everything anyway. There are no longer any succession duties, so we don't need wills anymore. Testamentary trusts no longer work. That's a new one. A trust can only continue for 21 years. And that's because people are thinking about the 21-year deemed disposition of capital property in trusts, but that's a tax rule, not a trust rule. Insurance and RSP beneficiary designations in wills are subject to probate fees. And my favorite, the $25 will kit, is lawyer approved. So this group understands that people shouldn't do their own wills, but again, it's amazing how often people have very good plans in place and then go and do something silly like, write out by hand, oh, by the way, I want to change my will and do this, and then they sign it at the bottom, and it's a holograph will, and it can disrupt all the careful expense planning. So we have a lot of planning tools at our disposal, and some of these are listed here. Multiple wills, which a lot of you may be aware of. In Ontario, we use the technique of having a secondary will, which will have assets that won't be subject to probate, and therefore we avoid probate tax in that way. Testamentary trusts, which I'll talk about a lot more. I'm really keen on these, and you'll hear more of it. Spousal trusts, again, like testamentary trusts. Carefully considered powers of attorney. Alter ego trusts for those over age 65, and principal residence trusts, which are, again, a favorite vehicle that I like to use. And there's several layers of tax on death that we try to avoid, but the thing to be aware of with avoiding taxes is that it may not make sense to jump through hoops to avoid tax. And that classic expression that the tax tail shouldn't wag the dog is very true. So sometimes there has to be an acceptance that some tax is necessary. And the first of that is estate administration tax, or what we traditionally have called probate fees. Sometimes it's worth paying the 1.5% probate fee in order to have other aspects of the planning done properly. So people will jump through hoops to put assets in joint name because they want to save 1.5%. And then in the process, they will potentially undo all sorts of other special planning that sets up trusts and wills. So, that's the one that we absolutely want to avoid it. And we do our best as planners to structure things to avoid it. But the fact remains it's only 1.5%. So there may be more serious issues that warrant simply biting the bullet and paying the 1.5% by having assets passed properly under a will that will be probated. The big one, generally, for most people, is the federal tax on capital gains, which is accrued and is realized by virtue of a deemed realization when a person dies. So when a person dies, there's a deemed disposition for tax purposes of all capital property at fair market value, and tax must be paid in most cases at that time unless there's a rollover vehicle. U.S. estate tax. Now, I mention this because I practice in Ontario, but I find so many clients have U.S. property. Sometimes they own U.S. securities. We can generally deal with that and make some good planning suggestions. But a lot of Canadians, as you're probably aware, own U.S. real property, and that can be a concern for them. Land transfer tax, and you say, what does that got to do with estate planning? Well, it has an impact in terms of how a will is structured. So I had a client the other day say, oh, I want to give my one child the right to buy the property from the estate. Well, when you do that, the child has to pay land transfer tax on purchasing the asset from the estate. So it's something that, as a planning matter, is important to draft the document properly. And then other foreign tax, because again, people tend to have, with wealth, tend to have property in many jurisdictions. And a favorite is certainly places in Europe where, because of economic situation, some prices have become very attractive. And it's important just to be aware that there may be a tax there that needs to be planned for. So I talked about the multiple wills, and I just want to also mention that for many years now, estate planners have been doing multiple wills for private company shares, and the structure is such that you generally do not need a probate for closely held corporations, where everybody knows that the person has died, that there's only a handful of shareholders, and so no third party is going to demand a probate. And that's why we do probate. When you're selling real estate, the purchaser wants a probate because they want to make sure they're getting good title. But with private company shares, it's not necessary. And it's also not necessary for most personal articles. So I was hearing on the radio this morning the news about a recent high-profile art auction, and some Colville paintings went for well over $1 million. There may be a buyer in that situation who wants a probate, but in most cases with a personal article, the delivery of the tangible item is the delivery of the item and its good title. And as long as there's clear providence in terms of the owner's ownership and ability to give good title, nobody asks for a probate. So now in Ontario, I am consistently putting personal articles in the secondary will, and it's not just to save the 1.5%. There's also a very high level audit power now that the Minister of Finance for Ontario has in probate applications. So if a probate application is audited, then it has to be a complete listing of the values of each asset and the backup material for how those assets were valued. And I struggle with the valuation of personal articles because there's such a wide range of opinion. I mean, particularly a perfect example is jewelry. There's what was paid for it, there's the insurance value, there's the appraised value, the replacement value, and then what you'd actually get for it if you sold it. So rather than have that scrutiny and have to go about and spend a lot of money with appraisals in order to back up the probate values that were submitted. Putting personal articles in the secondary will avoids that process. It is a logical one, but spousal rollovers to qualifying spousal trusts or to the spouse outright. Again, I've mentioned trusts primarily in this presentation because I find that trusts accomplish a lot of objectives for testators. And as I mentioned, avoid putting in wills the right to purchase real estate. Make it instead a gift and then have an equalization in the residue clause so that, as most parents want, all children are treated equally. Now this sounds like common sense, but again, you'd be surprised. Choose sensible executors. People often make emotional decisions when they choose an executor. And it's really important that the person will have the skills and the common sense that's needed. I always recommend that there be more than one executor unless all the assets are passing to the spouse, and then it makes sense to have the spouse as sole executor. If there's 3 or more, they consider majority rule because otherwise all executors must act unanimously, and that can cause issues. They can have a deadlock, and the only resolution for that is to go to court and ask the judge to tell the executors what to do. Provide a mechanism for replacing executors and trustees. So when a will trust is going to go out to, say the youngest child is 35, and at the time the will is being done, the child is 3 years old, it's really important to say, well, will the executor you're naming today, if God forbid something horrible happens to the parents, will that executor be young enough when the youngest child is 35 to still be administering the estate? And then consider special executors for special assets like businesses or art collections because, again, those special skills can be very useful. So trust wills. This is, as I say, something that I want to talk about at length this morning. And bear in mind that trust wills also have other considerations attached to them. And under Ontario law, that's primarily the obligations for equalization under the Family Law Act. As most of you are aware, we have legislation in Ontario that says whatever assets are accumulated by a couple during the marriage is subject to an equalization on the death of the first spouse to die. So when I say it's a really good idea to put assets in trust in the will, that may attract a claim by the surviving spouse for an equalization payment because the assets have been held in a trust and not gifted outright. So it's not as simple as just to say put everything in trust. The family law act rights have to be considered as well. But that aside, what's really useful with trust is that it can prevent the surviving spouse or beneficiary from remarrying and giving everything to a second spouse. And you probably all heard those horror stories because they do happen, where children of the deceased never see the money. And it can be very, very unsettling for them, needless to say. Sometimes the second marriage is longer than the first marriage, so it makes sense that couples married for 20 years, one of the spouses dies, leaves everything to the survivor remarries and has a marriage that goes for 40 years. But it's certainly the only way to make sure that the children receive something is either to leave them a portion of the estate on the death of the parent or to leave a good chunk of the assets in trust for the surviving spouse. Another thing that I get frustrated with when I hear insurance agents telling my clients, oh, don't put the designation of beneficiary in the will because then you'll have to pay probate tax, that 1.5% on the insurance proceeds. Properly structured an insurance designation in a will, attaching trust for the beneficiary does bypass probate. And again, very important because if children are going to inherit insurance proceeds of $2 or $3 million at age 18, it's generally a disaster. The boys go out and buy the fastest car they can find for the money that they have. And it's just a problem, because it's not just what the child spends, but they also become vulnerable to financial predators. And the trusts continue to be an essential will planning aid. The fact that the federal government has shut down the income splitting advantages of testamentary trusts, to me, makes no difference in the planning that I do. And it was really a recent phenomenon where everybody seemed to be getting on the bandwagon and set up multiple trusts under your will, because historically every trust set up under a will was a separate taxpayer. And so the graduated rates that individuals enjoy also applied to trusts set up under wills. And that allowed pretty nice tax savings. But I always said, wrongly, they're not going to shut this down because you have to die to get the advantage. So nobody's lining up to die just so that their family can get some income splitting. Well, I was wrong, and it's been shut down. But there is still income splitting advantages. If trusts are set up for minor children or young children who have little or no other income, then the income is allocated to that child under the testamentary trust. And that child has graduated rates and personal deductions or tax credits. So that, for example, if we have high net worth family and the spouse says, well, I just want to give everything to my wife. And I will say, well, how old are the children? Well, they're 3 and 4. Are you planning private school? Oh, yes. So if we set up trusts for those minor children and the testator dies prematurely, then rather than the surviving spouse, in my example, the wife, investing and the inherited money and paying tax at top marginal rates, if trusts are set up for the individual children, then the income on the child's trust can be taxed in the child's hands. And a 3-year-old generally doesn't have any income. So income splitting advantages still continue to apply, depending on the beneficiary of the trust. And the other thing that's always an advantage of trusts is they can insist in protecting assets from the beneficiary's spouse should the beneficiary inherit and then suffer a marriage breakdown. And I'll say a little bit about that right now, because there is some protection under the Family Law Act with respect to inherited and gifted property, but the Act is not perfect and the protection is not perfect. And I'll deal with that a little bit later. Again, protect against the surviving spouse remarrying and leaving assets to the second spouse. Ensure that children from prior marriages are not cut out by the step-parent. So again, there's another situation where the testator may be widowed or divorced and there's a new spouse, and they want to give everything to the new spouse, and they then change the wills after the first one dies and cuts out all the stepchildren. This is a really critical issue. Protect the young or the spendthrift beneficiary, because as I say, kids who come into money too soon generally spend it foolishly or get victimized by financial predators. And again, protect beneficiaries from spousal claims. If there's trust under wills, it's really important, as I said, to think about the number of years the trust will continue, look at successor trustees, and anticipate this 21-year deemed realization of capital property in trust. And that really ties our hands as estate planners, because often parents want to leave the cottage, for example, in trust for the lifetime of their kids. And I have to say, well, you can have that trust for about 20 years, but then they're going to have to come to grips with what's going to happen. And usually the solution at the end of or just before the end of the 21st anniversary is to actually distribute the capital to the beneficiary. And in these trusts, I'm suggesting there always be included powers to effect post-mortem estate freezes, power to move trusts offshore. I mean, basically, try and make the powers as broad as possible so that the executors can respond to whatever the changing circumstances are after the death of the testator. Principal residence trusts. These are a wonderful vehicle. I use them a lot in wills. So there's like a principal residence trust for surviving spouse or for children. And although the 21-year deemed realization rule applies with principal residence trusts, an election is made by the trust and by the beneficiary that they will claim the principal residence exemption for the period of years it's owned. So it suffers a deemed disposition, but there's no tax. So this is just an ideal way to protect capital property. However, to consider how the expenses are going to be paid, and typically these trusts will say that the beneficiary pays the expenses, then you have to say, well, what if the beneficiary doesn't? If they default, if they don't pay the taxes and insurance. So these clauses are fairly complex, and sometimes there's a direction that a fund be set aside to pay the expenses, but they're a very useful planning tool in protecting beneficiaries. And again, with principal residence trust wills, consider the effect of remarriage, and it may be that you just leave the principal residence trust in place because if the beneficiary is a spouse and they remarry, the house will be under a trust and should not be considered a matrimonial home. Powers of attorney. Again, this sounds like common sense, but you have to take care who's named. And I had a recent horror story told to me, and I listened to this and just thought, what an unmitigated disaster. And what had happened was the husband and wife, and the husband had a business. 4 children were all employed in the business. One was apparently a bright light, the other 3 maybe not so much, but this was their career. And the children were in their mid to late 40s, and the wife never had anything to do with the business, hated the business, didn't understand the business. So unfortunately, the husband developed Alzheimer's and had to be put in a care facility. The wife was sole power of attorney, just sold the business. First of all, she asked a trusted friend to come in and give advice, and then sold the business to this trusted friend for perhaps under market value. And then the first thing that he did was fire the 4 children. And it goes on and on. She sold the city house, she sold the cottage, she kind of had a mental breakdown, I think, from what I could understand of the story in this crisis. And it just, like everything, unraveled for this family. So, again, in those situations, it often makes sense to name the spouse as the sole attorney, and I do dozens of powers of attorney that are structured that way. But where there's a business and the spouse is not involved, it does make sense to name someone else, or perhaps have a power of attorney, a specialized power of attorney for the business assets, naming an individual who's going to understand the business and not do something that's just plain stupid. And in that particular fact scenario, it would have made sense to put the son, who was the bright light and actually was running the business, on as one of the powers of attorney. And it's helpful to leave instructions on management issues and what should happen in those types of situations. And again, important that the attorney have lots of powers so that sensible estate planning steps can be taken. And an alternative vehicle to powers of attorney, which again I really like, and I like them even more now that the testamentary trusts no longer have an income splitting advantage, is alter ego trust. Because unlike a power of attorney document, which is usually about a 1-page document, alter ego trusts are complete comprehensive plans with all the necessary powers generally to administer the assets. And there's a lot to be said for alter ego trust. Now, the settlor has to be 65 or over. all the income has to be paid to the settlor, and no one other than the settlor can receive capital gain during his or her lifetime. The trust, when the settlor dies, is not subject to probate because it's a separate entity. And after the death of the settlor, all the income thereafter earned in this trust is taxed at top marginal rates. And that used to be a huge deterrent for alter ego trusts, because under the testamentary trust you get the graduated rates for the trust that was set up after the death. Because that advantage is no longer really significant, I think we'll see a lot more alter ego trusts. So as I said, they're not subject to probate, so it saves the state administration tax. It's a private document, which I really like. It can protect the settlor from predatory caregivers, which we're seeing more and more of. It's a very disturbing trend. And the trusts that already exist at the time of death are harder to contest. So we heard about Tim's discussion about the Neuberger decision and the importance of probate, and that it's, you know, the public document and all this traditional law that Eileen Galeese talked about. Well, she's an academic before she was a judge, so she isn't just a tired lawyer. She's a ivory tower academic. But there's none of that nonsense with an alter ego trust or any inter vivos trust, because it doesn't get probated. So in the time I've got left, I have kind of list of other things that are maybe on a more sophisticated level that, again, this is more like a checklist depending on the individual and the assets that they have. So for people who are business owners, we almost always, when they come to see us, have a discussion about should they be considering an estate freeze. And you know, there's a variety of reasons to do that: deferring future tax on capital gain, more importantly, multiplying the capital gains exemption on qualifying small business corporation shares, etc. These are structures that are sophisticated but are basically what I would call bread and butter tools for the business owner. And then we also have, you know, always discussions about asset protection. So again, this is like a checklist of things to think about. And some of the more mainstream things in this list is designate beneficiaries of life insurance and RSPs, because that passes the asset outside of the estate and sidesteps creditor claims. And that, you know, could include all sorts of potential claims, and sometimes including potential spousal claims. Word about RSPs: there's a recent decision of the Tax Court of Canada, Kuchta, where the RSP designation did not exclude CRA's, the Department of Finance, ability to go after the beneficiary of the RSP for income tax debt under Section 160, subsection 161 of the Income Tax Act. But there's a decision from about 2004, I think, Amherst Crane, which said RSP proceeds that are subject to a beneficiary designation on death are outside the estate for creditor claim purposes. CRA has higher rates, so it's a little different for subsection 161 claims. Joint property ownership also. Now, I've just said, you know, don't always put things in joint name necessarily, but joint property ownership does pass assets outside of probate, as do principal residence trusts. So again, not subject to creditor claims. The alter ego trust, joint partner trusts are a similar vehicle, which are good creditor protection vehicle. Sometimes, in extreme cases, clients put their assets in offshore vehicles. And obviously, that's for the mega wealthy. And the other thing that sometimes is recommended is to set up multiple inter vivos trusts for the different family members, from like children from a first marriage and a second marriage that are fighting, or they're fighting with their step parent or whatever, just to, again, avoid the type of awful litigation process that happens when a will goes through a probate. It won't prevent completely the litigation, but it certainly helps. And I don't have too much time left, so I think I'm just going to talk about gifts to children, married children and unmarried. This is an area where, again, care needs to be taken because a gift that is made after the date of marriage is excluded from the beneficiary's net family property. And the income earned on it can also be excluded if the giftor or testator has declared that the income is to be excluded. And that's kind of a classic clause now that's in wills. When there's a gift made, I always have a deed of gift to document it and have that declaration. However, if the child takes that asset and puts it into a matrimonial home, the parent gifts the child $100,000, and they put it into a matrimonial home, the exclusion is completely lost. And so that's why I usually recommend that parents make loans instead and they take back security. And if they're buying the kid a house and the kid's getting married and the couple's going to live there, again, consider putting it in the trust for the child. Don't give them the money because they'll lose that protection. And the other thing to bear in mind is that there's a glitch in the Family Law Act where gifts and inheritance received before marriage do not have the exclusion for the future income or capital gain on the gift. That is not protected. Only the value of that inherited or gifted property at the date of marriage is excluded. So special planning has to be done in the event that a child inherited or had gifted property before marriage, and estate planners can help with that. There's a technique where a gift is made after the date of marriage and an estate freeze with respect to the assets that go into the marriage. So it is correctable, but it's a little more challenging. And in the time I've got left, I just want to talk about interim will clauses, and I love that word. This is the clause that says, if anybody contests my will, they'll be cut out and they won't get anything. Those clauses are considered void as against public policy. So, you know, you often see them in wills and people want to put that in a will. The technique that's important if one of these clauses is going to be used is that there has to be a gift over to someone else if the person contests the will. So rather than just saying, if they contest, they're cut out, it has to say, okay, I give to my child whatever, but if he contests the will, then this gift is going to go to my other child or go to my niece or nephew or whatever. That gives someone else a right to the gift, and therefore the interim clause is effective. My personal preference is to switch it up a little bit and provide that there's a condition precedent to the child getting the will, and that condition precedent is that they sign a full release and basically releasing all claims they might have, and that they get independent legal advice and so on. Because that way you don't get into the public policy issue. The condition precedent to a gift is pretty sacrosanct. So I think I'm going to finish there. As I said, I have a lot of material in my overheads, including the U.S. estate tax, which is something that we are always looking at for clients. But I think the thing to remember there is that if your clients do hold U.S. property, that they should get advice. Because if their worldwide estate is going to be more than about $5.5 million, that's U.S. dollars, they could have some exposure to U.S. estate tax. Thank you.
Thank you, Lindsay. We've come to the end. We are available here for questions, but rather than keep you because we hit our ending time, we'll say thank you for attending, and please fill out your forms. We look forward to getting your comments and suggestions, and look forward to seeing you next time. Bye for now.